Welcome to Just Liberty, where justice and liberty meet. I'm Bettina Krause, editor of Liberty Magazine, and I'm here with my co-host, Alan Reinach, who is president of the Church State Council. And together we're trying to take back religious liberty from the political extremes. Now, in that project that we're engaged with, Alan, it seems to me that the government these days is not helping us, because some of the speech, some of the messaging that is coming out of the current administration seems designed to stir up religious contention rather than to settle it down. And that is the topic of our podcast today. What happens when the government takes a religious position and speaks about it? What are the constitutional issues involved? So, Alan, why don't we go ahead and get that interview started?
Well, we are very happy today to have back as our guest an old and dear friend. Alan Brownstein is an emeritus con law professor from UC Davis, California. He has been one of the foremost scholars of church state here in America. In his career, it's been one of his primary academic focus points, and certainly a friend to Seventh-day Adventists. We've worked together on so many projects and all over the years. So, Alan, we're delighted to have you back for a discussion about, the government is, and this administration is engaging in overtly religious speech to a greater extent, really, than anything I've seen in my lifetime. And I guess the question is, should it, in terms of our church state understandings and concerns, is it a concern that the government is engaging in so much overtly Christian speech? And let's just start there.
Okay, it's a good question. It's a good place to start. But just let me say I'm very pleased to be here and talking to both you and Bettina. My relationship with the Adventist community goes back a very long way. I consider them allies in fighting for religious freedom and religious equality. So I'm very pleased to be here and to participate in your program. I think there are a lot of reasons why we should be concerned when the government expresses religious messages and promotes particular religious beliefs and ideas. And the reason for that is that I think the foundational premise on which the religion clauses were based, and those premises were only amplified by the adoption of the Equal Protection Clause in 1868, and its recognition that equality as well as liberty were very important constitutional values that the courts needed to pay attention to. But the foundational idea that really underlay the religion clauses was the idea that religion belongs to the individual and to religious communities, not to the government. And we should decide what we believe, how we worship, which faith we want to identify with. We should make all of those decisions independently of the influence of government. And when government expresses religious messages and promotes religious ideas, it is taking sides. It is promoting certain religious ideas, certain religious communities, and implicitly disfavoring others. And that seems to me to be fundamentally inconsistent with the basic idea that religion belongs to the individual. We speak with our own voice to God, to co-religionists, to the community. The government really doesn't have a place in participating in that discourse.
Professor, I wonder if you can help our listeners understand what exactly we mean when we say government speech. Because, it's not that the government is issuing, something from on high. It takes a form of either individuals doing something or saying something. And sometimes it's not even speech, right? So what are we talking about when we say speech?
And it's a very good question. And government communicates in a lot of different ways. It isn't always just officials. Sometimes it's the state legislature. It's a state legislature in Texas which enacted a law that said the Ten Commandments have to be posted in every classroom in Texas. So sometimes government acts institutionally, sometimes individual actors are expressing religious ideas and messages. Sometimes the government is communicating passively with displays. Other times it's communicating much more aggressively through state or teacher directed prayer, for example. When the government tells either students or the audience at a town council meeting to stand up and join us in prayer, that's not a passive display. That's asking either children or the people attending the town council meeting to participate in a religious exercise. And certainly, as a matter of historical fact, one of the things that was a hallmark of religious establishments was being compelled to attend religious services. That was recognized as something the Establishment Clause was intended to deal with. There are plenty of other hallmarks as well. But government talks in a variety of different ways. We can impute messages from government regulations. But my focus here is when government is essentially communicating. It's not doing much else with the particular conduct that's at issue, other than expressing a religious idea or message in one of a variety of different ways.
Let's put some more legs to this. You specifically mentioned Texas's bill requiring the display of the Ten Commandments, and clearly that's to say it's passive to me is to say, well, maybe it's not as offensive as something else in terms of our constitutional order. Maybe we get into that in a bit, but because I think it is pretty egregious myself. But what about what about the extent to which officials within our government today are really promoting Christianity among the employees of the federal government in a very public way? Can you give us some examples of what's happening and just how it sends a message to those who don't share those beliefs that, do I really belong in government? Am I really going to be treated fairly when it comes to, say, promotions, for example?
So let's distinguish between two kinds of government messages. Okay, one is where a government official like the Secretary of Agriculture issues a statement to the thousands of employees who work in her department, celebrating Easter with extremely sectarian language. I think the title of her message was, "He has risen." There was no doubt about what was being communicated here. This is in essence government proselytizing the beliefs of a particular faith. And I think government has no business doing that. That should be actionable under the Establishment Clause if we had a Supreme Court that considered the Establishment Clause to be an important limit on what government does. I don't think the current Supreme Court thinks the Establishment Clause means much of anything today. And I expect that.
We may well find out, what they think about that particular issue. I'm aware that a colleague of mine has joined with Americans United for Separation of Church and State to bring that very lawsuit, and I'm hoping that we'll be able to have a conversation with him at some point on this podcast. But anyway,
I'm aware litigation is being pursued. I'm not optimistic about how it's going to go.
I hear you. All right, so that's one example, overt government proselytizing. For listeners who are Christian, it may be a challenge to wrap your brain around, but what if the secretary of your agency was proselytizing, hey, it's going to be Ramadan in a few days. Are you ready for your fast? Something like that. I think the way to understand why something is a problem is to kind of turn it around. And if it was somebody else in the majority and you're in the minority, how's that going to feel?
It's exactly right. In fact, I wrote a short piece. I think I co-authored it with Vic Amar. And we basically said, the Constitution isn't a theological document, but the best way to understand it is to recognize that it supports the golden rule. Do unto others as you would have others do unto you. And the best way to think about things like free exercise or the Establishment Clause or freedom of speech is to ask, well, suppose this law is being imposed on someone like me. It's my religious faith that's being burdened. The message that's being communicated is really antithetical to what I believe. So let me give you an easier example than Ramadan. So we have this Texas display of the Ten Commandments. One of the commandments, as you know, let me put on my glasses here, is remember the Sabbath day to keep it holy. That's the version that Texas has adopted. Well, suppose it said, remember Sunday, the Sabbath day, to keep it holy. I'm sure people in my community, the Jewish community, and people in the Adventist community would find that to be very problematic because it excludes them. But really, there's no difference between saying that and saying, remember the Sabbath day, because non-Abrahamic faith traditions don't have a Sabbath. Hindus, Buddhists, Taoists. I don't believe Muslims have a Sabbath either, although they are part of the Abrahamic tradition. So You're leaving out a whole lot of faith communities, a whole lot of individuals, not to mention the people who aren't religious at all.
You may recall
from this message.
You may recall our colleague, Professor Andrew Koppelman. He has some more outrageous examples of, well, if government can, freely speak on religious subjects, it could require the display on every schoolroom bulletin board statements like the Pope is the Antichrist, right? Or what was the other one? Islam is not a real religion.
Yeah, there's no limit, I'm old enough, so I remember when students in my public school were instructed to recite the Regent's Prayer. This was the prayer that was struck down in Engel versus Vitale in 1962. And remember, at least in theory, there was an opt-out to the requirement that students recite that prayer. And let me tell you, that was honored in a breach. All the years I was in public school, no one ever said you could opt out. But in theory, you could. So that was a religious message that didn't formally coerce anybody, because you couldn't literally be punished for saying, I don't want to participate. But most of us would recognize that that is egregiously coercive. And we don't think government should be able to proclaim that message to our children. Now, how much changes if the Regent's Prayer is posted on the wall of every classroom in Texas or New York or wherever people are living. Since there was an opt-out anyway, there really isn't that much of a difference if you're insisting on formal sanctions or the formal denial of benefits before you're going to conclude that what the government is doing is impermissible. But I would think it's very, very problematic to have the government post prayers on schoolhouse walls.
So, Professor, all that we've been talking about over the past few minutes is about the Establishment Clause of the First Amendment of the Constitution and how that is interpreted. And I want to dig into a little bit dig into what you mentioned earlier, which is you're not optimistic if one of these cases goes before the Supreme Court that they will rule in a way that gives the Establishment Clause some legs. The Establishment Clause has been interpreted differently at different points in American history. From the beginning, it didn't even apply to the states. 1947 onward, it did apply to the states, and the way that it is understood has evolved. Help us understand where the court currently is when it comes to the Establishment Clause. How are they interpreting these cases?
Okay. The current court has essentially rejected all of the doctrine that previous courts had accepted. There were various tests, the Lemon test, the endorsement test. I don't want to spend a lot of time describing them, but there were frameworks that the court employed to give meaning to the Establishment Clause, to identify government conduct that violated this constitutional requirement. And the current court has pretty much rejected all of that. And what it substituted in its place is looking at history and tradition, primarily history, and primarily the history of around 1789, 1791. And it's looking for what it calls hallmarks, particular conduct that most everyone would have recognized, let's say in 1791, as involving a religious establishment. Hallmarks might be things like compelled attendance at a house of worship, or having to pay taxes to fund religious congregations or religious schools. Now, the real problem with that approach, and well, there's several problems. One is history is in the eye of the beholder. And there have been so many different interpretations of what colonists believed, what the framers of the Constitution believed, that when you say this is what history tells us, you're really saying this is what the history that I choose to identify as the critical history tells us. Because there will be plenty of historians who will disagree vehemently with your conclusion. But the other concern I have...
Alan, we even have a name for that. We call it law office history.
That's right, law office history. Now, the other problems with this approach is that you're looking at these hallmarks as if they are isolated problems, isolated conduct that people recognized as part of a religious establishment. And you just try to draw analogies to a particular kind of conduct that was identified as an establishment. So in the Ten Commandments case, the court could say, well, we don't see anything like the Ten Commandments in 1791 being posted on public school walls. Of course, part of the reason for that is there were no public schools in 1791. But they're looking for analogies to specific kinds of government conduct. And I think that's a very mistaken approach, because what they should be looking at is what are the principles and values that are reflected by those hallmarks, that underlay those hallmarks. And that's where you would see ideas like every man should be determinant of his own beliefs, that preferentialism among faiths is problematic. If you just look at the manifestations of religious establishment and not the reasons why people were concerned about religious establishments, you get a very short-sighted view of what establishment of religion was and is. And finally, the reality is that both the Constitution and the United States have changed dramatically since 1791. The Equal Protection Clause was adopted and ratified in 1868, and that sends a message of equality among groups based on a variety of different characteristics, which include race, nationality, religion, whether you're a non-marital child or not. And that message about equality has permeated a lot of areas of constitutional law. It wasn't part of the Constitution in 1791, but it is now. And you have to take into account the reality that the Constitution itself has changed over time. And of course, in 1791, we were an overwhelmingly Protestant society. There was Protestant hegemony, essentially. Very, very few Jews, very, very few Catholics, and virtually no Muslims, Hindus, people of other faith traditions. Today, we live in a much more pluralistic society. And the Constitution has to recognize that reality, that this isn't the world of 1791. If we care about liberty and equality, we have to care about liberty and equality for groups that didn't even exist 200 years. Adventists didn't exist in 1791. Mormons didn't exist. Jehovah's Witnesses didn't exist. So you have to accept that these values and principles have to be applied to a different world, a different society. And if you do that, and if you adopt what I think are the critical values underlying the Establishment Clause, which is, one, religion is the individual's business, or the religious assemblies and congregations, they're all voluntary and private. It's not the government's business. And two, given the pluralistic society we live in, the way government should deal with religion is to treat everyone of different faiths as if they are of equal worth and deserve equal respect.
So, Alan, when I was a history major as an undergraduate, I set about to do a term paper on the Establishment Clause. And I recognized that the terminology of establishment was something that was really foreign to us. At that point, it was the 20th century. And so I went to study the historical sources and to find out, well, what did our founding fathers mean when they talked about no establishment of religion? What were the colonial establishments? What were their concerns? So I've always been something of what the theorists call an originalist. That that the starting place is, well, to understand what we mean by establishment. But I certainly agree with you, and I pointed out, we were at a conference together recently, that if you're going to use the hallmarks, there's a fundamental problem, which is the Supreme Court's already ruled 180 degrees opposite of the hallmarks when it comes to the Sunday law cases and when it comes to government funding of religion and religious ministries and education, right? So, now you're going to have a doctrine that begins with holes big enough to drive a bomber through, right? It's not really a very good basis for judging the way it's conceived. And I certainly agree with you that, yeah, if they would use that to go and determine some basic principles, right? And the idea that, okay, government is not going to put its thumb on the scales, in favor of or against particular religions or religious beliefs or religious practices, that we're going to protect everybody's religious freedom, everybody's right to their faith. That's really the extent of government's role, is to protect all of us and our liberty. Great. But it may be too soon to tell, but it does not seem like that's the direction that the Supreme Court's likely to go.
Particularly with regard to religious speech and religious messages. They don't seem to be very sympathetic to religious messaging of religion as part of the problem that the Constitution is intended to deal with. And as you just said, Alan, one of the problems with being an originalist is that the originalists all discard the history that they don't find useful. So I'm waiting for originalists to grapple with the fact that the colonists were virulently anti-Catholic. They did not want to protect members of the Catholic religion. They viewed the Catholic Church as a threat to religious liberty, not as a faith that needed to be protected by the Constitution or by laws. People forget that the Quebec Act, which was the act in Parliament that guaranteed religious freedom to Catholics in Canada, that was considered one of the intolerable acts by the colonists. That was outrageous to them, that the British government was protecting the religious liberty of Catholics who weren't even in the United States. They were in Canada. And that was considered so dangerous and so threatening that it was listed as an intolerable act. And of course, go ahead.
The irony here is that the historic Protestant opposition to public funding of Catholic parochial schools was used as a basis to completely turn around the constitutional prohibition on government funding of religion. And it was Protestants joining with Catholics that have been part of that effort in recent years, right? So the very fact of the kind of anti-Catholic attitudes that we had for, I don't know, a century or more in this country have been turned against our historic traditions. Because I don't think my criticism of some of these cases has been, it wasn't an anti-Catholic tradition that led to the Establishment Clause and the notions, the experience in Virginia that kind of said, yeah, we're not going to fund religion. That had nothing to do with Catholicism. Now, were there other, developments in the state subsequently, decades later? Yes. It became an issue in the latter part of the 1800s when there were waves of Catholic immigration. But, to turn out our whole constitutional tradition because of that never made sense to me.
It makes no sense to me either. I'm no fan of religious bigotry against any faith community.
Agreed.
But the reality is, if you're going to look at our history and say, I'll accept some of it because it seems to reflect good values, and I'll reject other aspects of our history because that expresses bad values, well, you're not an originalist anymore. Then you're superimposing modern values on history. And I don't think that's avoidable. I think that happens all the time. But you ought to be upfront about it and say, well, we're not really originalists. We recognize that we construct history. We don't just discover it. And in constructing it, we are superimposing our own values, whatever they may be, on that historical account that we're evaluating. And the current court doesn't seem to want to recognize that. Yeah, if you ask them, Justice Gorsuch is a significant defender of Native American rights, but as an originalist, you can't say that anyone cared about Native American religious liberty in 1791.
Roger Williams did 150 years earlier, but he was long gone.
I wrote a piece about when students were saying we should be allowed to protest anything because there's something good about dissenting from government and being a protester. And I wrote a piece that said, really, you want to know one of the earliest protest movements in the United States? It was the Paxton Boys. And that was a movement directed at the colonial government of Pennsylvania. And what the Paxton Boys were upset about was that the colonial government of Pennsylvania was too accommodating of Native Americans. And they were denying people bounties for Native American scalps. And so the Paxton Boys were protesting that. And I said, well, it's a protest. But, the fact that it's a protest doesn't mean that we should consider it to be substantively praiseworthy and deserving of respect.
So, Professor, we've been talking a lot about what the Establishment Clause means, what it's meant in history. But let me put forward an argument that I've been hearing a lot of recently, and it's an originalist argument that goes to how far the Establishment Clause binds the states. And that is that Everson versus Board of Education in 1947 was wrongly decided that we should go back to the original intent of the Establishment Clause, which was only to restrain the federal government and allow states and local communities to decide religious questions for themselves. I've heard this in a number of different places, not least articulated by J.D. Vance, and who also agrees that this is a good way to deal with the Establishment Clause, to get back to its so-called original meaning. How would you respond to that? And is that likely to get some legs?
Justice Thomas has taken that position,
yeah,
and argued for it in a variety of opinions. As near as I can tell, he hasn't influenced anyone else on the court, and it's a conservative. Maybe he's influenced Justice Gorsuch, but even though it's a conservative court, he doesn't seem to have convinced a whole lot of Supreme Court justices that the Establishment Clause wasn't incorporated at all in 1868 and has no binding force on states. And there's a lot of scholarship that's been written that demonstrates that while that may have been the original understanding, by the time you got to 1868, there was a recognition that the Establishment Clause meant more than a jurisdictional statement, that there was substantive principles and values that were part of what the Establishment Clause prohibited. I shouldn't say prohibited, endorsed and tried to enforce. There were, government territories, for example, had Establishment Clause, like the Northwest Territory, had Establishment Clause provisions in their preliminary constitutions. And it would make no sense to put an Establishment Clause in those documents if you thought it was purely jurisdictional. And that clearly indicated that there was something of substance that the Establishment Clause captured, and something of value that needed respect. Now, another way to think about this is that the Establishment Clause jurisprudence over the last 100 years or so, I think, has very much incorporated equal protection values. And I think the court had really two choices after Brown versus Board of Education was decided, after it became clear that the court was going to take equal protection seriously, and it wasn't going to be a constitutional dead letter as it had been from 1868 until Brown was decided in 1954. So the court could have developed an equal protection jurisprudence that dealt with religious equality. And religious equality is mentioned incidentally in a few equal protection opinions. But instead, it decided to use the Establishment Clause as the doctrinal framework for protecting this value of religious equality. But even if you want to insist that the Establishment Clause was the wrong constitutional provision to use to promote that value, you're still going to have to deal with the value because the Equal Protection Clause is still there. And if the argument is we have to go back and develop all of the same kind of arguments under the auspices of the Equal Protection Clause, well, you could do that. But it seems that people like Vance and other people who are saying the Establishment Clause was simply jurisdictional and has no substantive meaning, they don't really want to pay respect to values and principles like religious equality. And what that would mean is every individual state could have an established religion. Is that really the kind of society we want to live in, where if you move from California to Indiana and you're a member of a minority faith, you have to start thinking about, well, what will my rights be in this new state that I would be living in? How will my children be treated in the public schools? Will we be essentially told we're second-class citizens because we're a member of a minority faith, that we're really no more than guests in the state that we've moved to? We don't belong here as of right. And I think that's a horrible framework for the United States. And I don't expect the court to adopt that position.
Well, I also think that it's a very doctrinaire approach to the Constitution that ignores the actual history, right? Because there was really very little interest in defending religious establishments anywhere by the time of the Constitution. Most states had already disestablished. The last ones were not far behind, Massachusetts being the last in 1833. So there was nobody was pushing for state establishments of religion. What they were doing on a principled basis is something much more modest and saying, look, the Constitution, we're focused on federal power. We're focused on what are the rights and limits of the federal government. And if memory serves me, Bettina, Liberty Magazine recently published an article about just how modest was Madison's effort in approaching the First Amendment. They weren't trying to do something radical. They were content with how the states were pursuing disestablishment and all. So again, context is king. We can cherry pick our history to prove our own point of view, as you said so well earlier.
Another way to think about this is, remember that the Constitution in 1791 was a deal among 13 states that really didn't have all that much in common, other than they were located in very close proximity to each other. They disagreed on a huge number of issues, not the least of which was slavery. And we don't have voting as a codified right in the United States Constitution because it didn't seem possible to achieve a consensus on who would be allowed to vote. So they left it out. But if you asked people today whether they thought there's a fundamental right to vote, I think everyone would say, absolutely, there is. And it's a federal constitutional right. We have a right to vote whatever state we move to. And that's simply the reality that the deals that were made back then have to be evaluated pragmatically to recognize that we've become more of a United States today than united states, each state being a very separate jurisdiction. We're all Americans now. We identify much more as Americans than as Californians or New Yorkers. Although when the Knicks won, that made me a New Yorker, again, at least temporarily.
Well, Alan, I've often said, we both grew up in New York City. You can take the kid out of New York, but you can't take New York out of the kid.
Right.
So,
I believe that. I usually say it with regard to the Bronx, but it's true of New York generally. So, we have to grow up to the reality that we are a nation now, and we need pragmatic constitutional doctrine that recognizes that we're a country where people can move around and expect to be treated as if they are of equal worth and deserving of equal respect, regardless of the state they live in. And that's critically important.
And I think that thought, Professor Brownstein, is precisely where we need to leave this issue. We're all Americans and we have certain values that allow us to live and work and worship in a way that is equal to all our other fellow citizens. So thank you so much for helping us explore some of these complicated but such important issues today.
well, Bettina, I thought that was a really fantastic interview with Professor Brownstein, my old and dear friend. We did not get into a lot of the specific issues of what's happening today. He did mention the Ten Commandments, and I think our listeners know that that's gotten a lot of press. People are aware of the Texas bill and maybe the litigation around it to post the commandments in the public schools. And he mentioned the Easter greeting by the Secretary of Agriculture. But of course, there's a lot of stuff that Pete Hegseth, the Secretary of War, has done. We didn't get into how aggressive his Trump's own pastor, Paula White Cain, has been in publicly, praising Trump as God's man in the White House and such like that. So if, maybe there's another show there to be had where we really dig in and because my sense is that most Americans are living their lives, right? And they're not necessarily tuned in to these kinds of issues and the challenges that may actually impact their rights, how well their rights are protected.
So, Alan, I worked for many years, as you know, in government affairs, and part of my job was to interact with the White House Faith Office. And there's nothing new at all about the Faith Office issuing congratulations or commemorating different religious festivals of different religious faiths. It'll come out with a statement about Easter. It'll come out with a statement about some Islamic festival or holiday, a Jewish holiday. But what we're seeing today is in a different category altogether. I was on the National Mall a few weeks back, May 17, the Rededicate 250 event, where the Trump administration, it had entered into this public-private partnership. So it wasn't fully the Trump administration, and it wasn't fully the private organization. They were working together to put on an event to rededicate America to God. Now, that to me is just simply an eye-popping situation, because here we have overt government speech that not only puts its thumb on the scale, it comes right out and says we are a Christian nation. And for, like you say, Alan, people aren't really following this. They really should be, because we've gone through a sea change.
So you bring back to mind As a young law school graduate, I was involved with a religious liberty organization in New York that had brought a number of Supreme Court cases in going back to the 70s, maybe the late 60s and 70s. And so now we're in the later part of the 80s. I attended a lunch with a prominent Jewish lawyer as the speaker. And I'll never forget the metaphor that he used. He said, look, if America is a Christian house, then we Jews have no right to complain about, the Ten Commandments up on the schoolhouse wall or the crosses or, whatever government favoritism of the Christian faith. But if America really is a house that belongs to all of us, well, then it's inappropriate. It needs to be inclusive of everybody. And what I hear you saying, and I wasn't there, and I haven't talked to anybody who was there, so I'm happy to get your firsthand report. It's totally inappropriate, and let's be clear. What this administration did in that rededicate America to, they didn't rededicate America to the sort of one size fits all God, right? They rededicated America to a very Christian God, and a Christian God in after their own imagination. And I say that because one of my major preaching points these days, Bettina, picks up on Jesus' own warning about many false messiahs in the last days in Matthew 24. And I point out that, there's a few actual human beings who have styled themselves as Christs. We can name the list that we're familiar with. But I said there's a bigger problem. And the problem are all the Jesuses that we ourselves make in our own image. And so we have rededicated America, or they did, I should say, to a Jesus. I'm not sure it's the same Jesus that I know or that you know. I think that there's a number of versions of Jesus, and it goes beyond the whole concept of the blind man and the elephant, because, not all of them are simply seeing through the glass darkly, so to speak. Some of them are just plain idolatrous and heretical.
So, Alan, I think we need another program that really digs into this issue, because I think our self-understanding as Americans, who are we? Who are we for? Why does this nation, what is the purpose of this nation? What are the founding principles of this nation? When we wrap it all up in religion or our understanding of religion, it becomes not only dangerous, it becomes, it excludes. It becomes very exclusive. And I think we need to really sit down and have a proper discussion about Christian nationalism as it appears today.
Very good. To be continued. This has been Just Liberty, where liberty and justice definitely meet. Again, I'm one of your hosts, Alan Reinach, with Bettina Krause. Until next week, remember, eternal vigilance really is the price of liberty.